Good morning, everyone. I am Danridge Mejia, and I will be discussing the principles of international trade law. Principles of the trading system. The World Trade Organization agreements are lengthy and complex because they are legal texts covering a wide range of activities. They deal with agriculture, textiles, and clothing, banking, telecommunications, government purchases, industrial standards, and product safety, food sanitation regulations, intellectual property, and much more. But a number of simple, fundamental principles are the foundation of the multilateral trading system. National Treatment Principle. Imported and locally produced goods should be treated equally at least after the foreign goods have entered the market. The same should apply to foreign and domestic services and to foreign and local trademarks, copyrights, and patents. These principles apply to trade in goods, trade in services as well as trade-related aspects of intellectual property rights. What is national treatment? National treatment is a concept of international law that declares if a state provides certain rights and privileges to its own citizen, it also should provide equivalent rights and privileges to foreigners who are currently in the country. National treatment is the principle of giving others the same treatment as one's own national. National treatment also applies to imported goods once they enter the market, which they should be treated the same as locally produced goods. Foreign and domestic services, and to foreign and local trademarks, copyright, and patent. Understanding national treatment. Under national treatment, if country A provides a special tax break for its fledgling pharmaceutical industry, all pharmaceutical companies that have operations in country A will be entitled to the tax breaks, regardless of whether the company is domestic or foreign. The concept of national treatment can be found in bilateral tax treaties, as well as in all three of the main World Trade Organization agreements, which are Article 3 of the General Agreement on Tariffs and Trade, Article 7 of the General Agreements in Trade Services, and Article 3 of the Agreement on Trade-Related Aspects of Intellectual Property Rights. However, the principles is handled slightly different in each of these agreements. When applied to international agreements, the concept of national treatment means that a state must treat citizens of other states that are participating in the international agreement the same when goods are imported under an international agreement. They must be treated the same as goods produced locally, although this obligation does not take effect until the imported goods have entered the foreign market. Advantages and disadvantages of national treatment. National treatment is generally considered to be desirable. However, it may not always be. In theory, the concept allows a state to effectively deprive foreigners of any rights or privileges of which the state also deprives its own citizen. For instance, suppose that a state has a law that allows it to expropriate property. Under national treatment, a foreign firm would technically still be subject to the expropriation law. Or, say the laws of a state hold that a married woman may not travel without the permission of her husband. Under the concept of national treatment, a foreign married woman traveling or living in that state would need her husband's permission to travel. Even if she would not need it in her country of origin. However, depending on the country, other laws may exist that could limit national treatment to only the upside benefits. While historically, governments, especially those of developing nations, have used national treatment to justify expropriations. These issues are usually dealt with contracts or treaties. An opposing principle to national treatment is that of the minimum standard of justice, which would provide foreign national access to judicial process and basis rights, protections, regardless of what they are allowed under the doctrine of national treatment. Second principle is the most favored nation. The MFN, or the most favored nations principles, ensures that every time a World Trade Organization members lowers a trade barrier or opens up a market, it has to do so for the goods or services from all World Trade Organization members, without regard of the members' economic size or level of development. The most favored nation principles requires to accord to all WTO members any advantage given to any other country. A World Trade Organization member could give an advantage to the other World Trade Organization members without having to accord advantage to non-members, but only to World Organization members benefit from the most favorable treatment. Trade without discrimination. Under the most favored nation principle, treating other people equally. Under the WTO agreements, countries cannot normally discriminate between their trading partners, grant someone a special favor such as a lower customs duty rate for one of their products. And you have to do the same for all the other WTO members.